the meaning of life. You sit today in such an epochal moment that what you do here has significant ramifications for the Republic of Kenya. It is for you as a court to rise to the occasion. This court has defined the Constitution as a transformative constitution. And this was done by this very court, differently seated. In the BBI case, David D. and others, versus the Attorney General. And this is what the court said about the Constitution 2010. It is a constitution of a transformative character. And this transformative character of the Constitution induces large-scale social change, including the character and conduct of politics. That the Constitution bears an internal theory of interpretation. Starting point for discerning that internal theory is Article 259 of the Constitution. That formalistic approaches to constitutional interpretation are not favored. And lastly, that the Constitution has provided for its own theory to protect its values, objects, and purposes. That is what is before you as a court today, that you are supposed to maintain that innate character of this Constitution as a transformative charter. The other side has filed grounds of opposition, and in their grounds of opposition, they raise a case, Lorna Conchela and others versus the Chief Justice. That was the grounds of opposition by the Attorney General. And in that case, this High Court said that the power to appoint a bench is administrative, and that power can be performed by the Deputy Chief Justice in limited, constricted circumstances, so that the normative holder, the Chief Justice, performs it, but the Deputy Chief Justice has to perform it in certain limited circumstances. Those limited circumstances have to be demonstrable. That is Conchela. Your Lordship Justice Murima, sitting in Okoiti versus JSC and another petition, E408-2020, 2021 EKLR, I believe that is what Professor Gidu Mugia was asking about. Paragraph 2938. Justice Murima finds that the authority under Article 165.4 is a constitutional authority, so that authority cannot be delegated by the Chief Justice, because the Chief Justice does not cease to be a state officer, even on leave. We have another authority here, Petition 31 of 2013, Kenya Medical Research Institute versus the Attorney General. This is found at 2014 EKLR at paragraph 37. Kenya Medical Research Institute versus the Attorney General and three others, 2014 EKLR. This case at paragraph 37 says this, that the Chief Justice under Article 165.4, the authority to empanel a bench, performs a constitutional mandate. And this is not an administrative function, as was in the old Constitution. Where do we go? I'll invite the court to look at the express wordings of Article 259.3a that expressly decrees that authority granted to a specific office must be performed by that specific officer. That is Article 259.3a. Allowing this court to consider the decision of the Court of Appeal, and this, the other side can take judicial notice of, the court can take judicial notice of the case of Karisa Chengo, whereby the office of judge and the person of judge are synonymous, such that the Chief Justice, the person, and the office of Chief Justice are synonymous. And therefore, we cannot separate and delink the holder and the person. And therefore, if the Chief Justice were to delegate any responsibility to the Deputy Chief Justice, assuming that was possible, then the Deputy Chief Justice has to take an oath by virtue of Article 74 of the Constitution. There has to be instruments prepared authorizing the DCJ to act as Chief Justice and for what purposes. Ladies and gentlemen, honorable court, the Greek tale of Ulysses, the coxswain who was asked to block his ears using wax and to avoid the temptation of alluring music, that story echoes well for you today. It's politics, there's a lot of heat and rancor, but for you, as the court, an apex court under the Constitution, yours is to uphold and defend this Constitution as required at Article 3. That's the sole mandate of this court. Thank you.
My lords, my lady.